In the most recent edition of the Wisconsin Lawyer, published by the Wisconsin Bar Association, it's the July/August issue. There's an article by Mark Fremgren, who's a family court commissioner from Dane County, and Tiffany Highstrom, who's a family law attorney from Dane County, entitled "The Review of Child Placement and Support Proposals." And what their article does is summarize a number of proposals that came out of the Legislative Reference Bureau studies and apparently will be proposed legislation before our legislature this fall. What I liked about the article is that not only did it summarize certain proposals which may become law in our future, but it gives the pros and cons of each of these proposals. And I thought it did a really good job of summarizing the various proposals and what the up and downsides are. And I want to comment on that for a moment in this, because I've had the misfortune, I guess, wasn't fortunate, was intentional at the time, of getting involved in some legislative projects a number of years ago. And to put it mildly, I found it relatively scary. Let me put it this way. At the time, my hair was not only black, but it was straight. And look at me now, after dealing with the legislature. The three that I dealt with were tangentially with a change to the property division statute. The Wisconsin Supreme Court, in its infinite wisdom, decided that life insurance proceeds were not inherited. Who knew? Along with a couple of other silly rulings that we wanted to correct. Much more so on the removal statute that just got redrafted and rewritten as the relocation statute that I commented on a few months ago, in terms of that it's mostly an improvement over the statute that I worked on. And the one that I'm most proud of is what most people call the automatic stay law. It was my pet project for about 3 years, to have orders go immediately into effect upon filing for the petitioner, upon service for the respondent, upon both if it's a joint petition, for pretty broad areas in terms of not being able to abuse the other party in any sense, to be able to destroy or encumber property, and also to relocate with the child without permission, and various aspects of all three of those in a little more detail. Since it was signed by Governor Thompson, the laws worked, I think, very well. A couple of changes I'd make in it now if I had to do over again, but for the most part, it served its purpose without creating any harm. And that's pretty much what I want to talk about in relationship with the bills that are summarized in the article by Commissioner Fremgen and Attorney Highstrom, which is the danger in legislation in what is known as the law of unintended consequences. And the part of it that was most scary to me was going to meet with legislators when I was working on these proposals, mostly the automatic stay one, because as I said, that was my pet project, and trying to convince legislators of the wisdom of it, which I thought was pretty much a no-brainer. Nobody was against it. It wasn't going to do any harm and might help some people. And the lack of knowledge of legislators in terms of how the law worked and what the statute could do was actually pretty scary to me. I found out at the time that there was something like 9 legislators that were lawyers. I think the count in the last session was 8, and that's out of 133. We have 100 state assemblymen and 33 state senators. And of the 133, it's at that time was around 9. I think now it's around 8 who had law degrees. And I want to clarify that, or be clear that when I say have law degrees, that didn't mean they practiced law. I believe in the last session, and I could be off 1 or 2, out of the 9 of them, only 2. One of my notes, of course, is Lena Taylor, state senator from Milwaukee area, and one other, I believe, who actually practiced law. The others are a couple of DAs, and the rest have law degrees but have never used it, which is a scary combination, of course, because then they have the knowledge without the experience. But even worse is the 125 that are enacting these laws who don't even have a law degree, yet they're making laws that affect all of us. The effect can be benign. There are some laws passed that just don't really make any difference because everyone pretty much ignores it. I'm thinking, of course, of something like the going back years and years ago, when the legislature passed the statute requiring medical records to be exchanged between the parties in quite some detail. Legislature later watered it down, but it was such a difficult statute to follow, created so many other problems that most people just ignored it. Same thing with the current law regarding parenting plans. Some counties do follow it and take it very seriously, and I hear it works really well. Milwaukee County, it's sort of like, really? You really want to do that? Okay. What is a parenting plan? And everyone just sort of ignores it. And in the video that I did a couple months ago about the new relocation law, I pretty much made the same point that, as I say, there are parts of it that I think are improvement in the current law. There are other parts that I just don't see anyone really following, particularly the time limits set forth in it that conflict with real life. If you're trying to get a hearing date in front of the Milwaukee Family Court Commissioner's office, good luck following those. And the gap between the theory, which may be perfectly good in a statute, and the reality as to how it plays out is to me relatively disturbing. Of the statutes that Commissioner Fremgren and Attorney Highstrom talk about, a couple of them are actually good. The one that I like is the one that would allow courts to make what are called contingent placement orders. That would be an order, for example, if the parties are getting divorced when the kids are 2, 3, and 4, to be able to say that when the child starts school, absent an intervening change of circumstances, as it currently exists, that the child would start school in such and such a district. The goal of that is to avoid litigation coming up in 1, 2, 3, or 4 years. If something changes, the child would be harmed. Any detriment to the child, of course, they can go back to court. But the Wisconsin Court of Appeals, in a case called Cindric, C-I-N-D-R-I-C, reached a rather stupid decision, in my humble opinion, of course, saying that that's against Wisconsin policy. Really? It's against Wisconsin policy to encourage parties to settle cases and to avoid litigating over children? Sometimes our courts aren't realistic in terms of what actually happens on the ground in terms of divorcing parties and especially their children. So that statute, I think, is pretty good. The one that's sort of benign is there's one on the placement issues that deals with essentially reordering the factors, putting them into a different order. I don't think it's really going to make any difference. The one that's problematic, though, is anything that deals with the placement schedule of children. Our current law was a compromise between divorced dad groups who wanted equal placement in every case and the family law section of the state bar that does look after children and realize that it isn't going to work in a lot of cases. There are a lot that it's problematic, and to require it in every case is really going to do quite a bit of harm. The resultant statute says that the court shall maximize time with each parent, which of course is a mathematical impossibility. If you're going to maximize with one, you minimize with the other, and there's no way of getting the math to work out on that, except the practicality of it actually works fairly well. And the way it plays out in real life is courts find that if everything else is equal, everything else meaning that the children aren't of such an age where they're going to vote by using their own car, neither party has any domestic violence convictions or issues, and domestic violence is not an issue. Substance abuse, mental illness And geography, importantly, is not an issue. You know, one parent that lives in California and one in Wisconsin. That everything else being equal, there you have two relatively decent parents, no major issues in any of the categories that I spoke about. The court starts with the assumption. And I'm using the term assumption, not presumption, because it's not a legal presumption, but the assumption that we're going to start saying, hey, there should be an equal placement schedule unless somebody shows me some really good reason why it shouldn't be. And the statute here tries to tinker with that, but the proposal through the Legislative Reference Bureau. Please understand that the the council, not the Legislative Reference Bureau, the council that considered these studies and that did the study proposals. Remember that these study proposals are put together by a group created by the same legislature that has virtually no lawyers who have ever practiced law. So they're, big shock here, political appointments. They're people that serve some political agenda in terms of being appointed. Fortunately, there have been a couple judges on it who know what they're doing. There have been a couple members of the family law section of the State Bar know what they're doing. And to the extent they can influence the recommendations by keeping them in line, they've done a really, really good job. It's not that the placement statute that we have now is perfect, but before you replace it, be careful of the old adage, if it ain't broke, don't fix it. If you don't have a better one, then maybe the one we have is working as well as anything can. And given the variations in families and children, in circumstances and issues involved, to try to lock it up in some sense that works in every case is very much trying to squeeze a round peg into a square hole. It just isn't going to work. It's not going to be a good fit. And the legislature keeps trying and trying. The reason, of course, that they keep trying to do that is a very simple one. The legislature, when faced with an issue and somebody complaining about something, is incapable of saying, hey, we're not going to do anything. So what the legislature does is try to do something to placate whoever's complaining about it. So take a look at the article, take a look at the arguments pro and con, and if you have the ear of a legislature, if it gets that far, don't be shy to pick up the phone, call the legislature, see if you can help one way or the other in terms of enacting these statutes. A friendly reminder to subscribe to Wisconsin Family Law Case Finder. Subscription information is on screen for you. We have over 1,600 family law cases in Wisconsin, many cases from out of state, organized into 135 different family law subject areas. You can search by the words, search by the area, search by the case. It's an outstanding resource, and if you practice family law in Wisconsin, you ought to subscribe to it.